Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers exigent circumstances, warrantless searches, and police tactics, and is brought to us by Susie D's channel. Be sure to check out the description below and give them the credit that they deserve. Before we get into the episode, I have a brief announcement regarding this channel. Many of you may already be aware of YouTube's new terms of service beginning on December 10th, 2019. The language of these terms are troubling, and this channel and many others may be in danger of being removed once these terms go into effect. The terms state that any channel which YouTube deems as not commercially viable can be deleted, along with the entire Google account associated with the channel. The phrase commercially viable is extremely vague and allows YouTube to indisputably delete any channel for any reason. I worry that some may interpret this channel's content as provocative, which is explicitly not the intent of this channel. I cannot speak on the exact intentions of YouTube, but I fear that Audit the Audit may be a victim of YouTube's heavy hand in the near future. That being said, I will be relaunching Audit the Audit's Patreon account with a new $1 a month tier so that I can keep creating content that is accessible to everyone. I will be regularly posting content to Patreon that is ad-free, uncensored, and exclusive to Patreon. Patreon's platform will allow me to cover a broader spectrum of interactions that I have intentionally avoided in order to conform to YouTube's guidelines, such as encounters involving shootings, violence, and vulgarities. I love this platform, and I will continue to post to YouTube for as long as my channel is alive, and by no means am I suggesting that you must support me via Patreon. This will be extra content that you can access if you want to. It is not a requirement. I cannot guarantee that Audit the Audit will survive on YouTube in the future, and this is a way to ensure the longevity of this channel. A new video is available now on Patreon, and you can find a link to the Patreon account in the description below. In the event that this channel is deleted, I will no longer be able to contact any of you to let you know. If you want to stay up to date on this channel's progress or lack thereof, feel free to follow us on Twitter or Facebook. Links for those are also in the description. I will also be starting a second YouTube channel as a backup to post mirrors and other important content. You can find a link to that in the description as well. Thank you for taking the time to listen to this announcement, and if you don't hear from me or are unable to locate this channel anytime after December 10th, then you know what happened. Now let's dive right in and audit the interaction. On May 3rd, 2015, at approximately 6:40 a.m., Gillespie County residents Huntley and Susan Dantzler were awoken by the sound of several vehicles approaching their home and a loud pounding on their front door in Fredericksburg, Texas. Upon answering the door, the Dantzlers encountered two Gillespie County officers, Deputy Hindman and Deputy Westbrook, who were searching for the Dantzler's son after receiving an anonymous tip that he was with an unnamed female whose health might be in jeopardy.
The way they go on, sir. All right, man. That's the way. All right. Been doing this for a long time.
Yeah, me too.
Okay. All right. Go ahead and stand right down here.
Can I see your badge, please?
Yes, ma'am. All right. Now we do need to go in just to make sure that he's not.
Show me the law.
Man, we don't. We've already explained that to you. We have already explained that to you. We are on recording.
So now we live in a police state. Now you're bullies.
No, ma'am. We need to make sure that he is here by himself, with or without a female subject that is under a possibly medical condition right now. Okay? That's all we need to do.
Take your hands off of me, man. Take your hands off of me.
Deputy Westbrook and Mr. Dantzler get into a brief scuffle after Mr. Dantzler refused to obey the orders of the deputy.
He's
Yes.
being detained, and if he's going to resist or fight with my officer, then my officer has to do what he has to do. Okay?
Now stand right there. You understand me?
Ms. Danzler, we need to go in and just make sure that he's not here. Is he here?
No, he's not here. I'm sorry that you deal with low-life liars day in and day out.
Okay.
If he was here, his truck would be parked right there, and you can see the evidence.
His truck is parked over
And
there.
it's
I
parked
said,
over
if
there.
he was here, it would be parked right here. You can see the evidence of where he parks.
Okay.
And how we can be past seeing the law when you offered it to me not too long ago, I don't know.
Ma'am, it's exigent circumstances. We have the right to go in there.
And you
Check the
also
welfare.
told
To
me,
check the welfare of
can
the
I
person.
show you the law? And now you're
We're
refusing.
past that point. We're doing it now.
Okay.
In the 1982 case of United States v. McConney, the Ninth Circuit Court of Appeals defined exigent circumstances as those circumstances that would cause a reasonable person to believe that entry or other relevant prompt action was necessary to prevent physical harm to the officers or other persons, the destruction of relevant evidence, the escape of a suspect, or some other consequence improperly frustrating legitimate law enforcement efforts. However, the history of exigent circumstances extends back much further than the McConney case. Legal scholars do not point to any particular case from which the exigent circumstances doctrine arose, but many attribute the foundation of the doctrine to former Supreme Court Justice Felix Frankfurter, whose stern dissents in multiple cases laid the groundwork for the development of the concept of a per se position with respect to warrantless searches and the first clear articulation of the reasoning and logic supporting the various exceptions to the per se rule. Over the years, the exigent circumstances doctrine has both evolved and devolved under the interpretation of various courts and has essentially amounted to a loosely outlined axiom which is generally considered on a case-by-case basis. Many courts have struck down cases that involve the invocation of the exigent circumstances doctrine, and just as many courts have upheld cases involving the doctrine. Often the rulings of these various courts are in direct contradiction from each other, which has left the doctrine somewhat ambiguous and difficult to both argue for and defend against in a courtroom. Courts have ruled that the emergency prong of the exigent circumstances exception operates as an extension of the community caretaking function of law enforcement officers. A warrantless entry or search that would otherwise be barred may be justified by the need to protect life or avoid serious injury. Given that Deputy Hindman and Deputy Westbrook were basing their search on the possibility of a medical emergency, it could be argued that their search was valid, but that is highly dependent on the interpretation of the presiding court.
Why am I?
Why do we have such a short
why am I-
window?
Why am I hearing movement around inside the house?
I've
Is
got
there
two
anybody-
cats.
Okay, you have two cats. That
And
doesn't-
plus, I just hit the door frame right here with my elbow when I turned.
Okay, all right. That may have been the case. Okay. Regardless, I need to go in just to see if he's here. Okay. All right.
How about if you walk right over there to the very last window and I pull back the curtain and you can see he's not in his bed?
No, ma'am.
You said all we need to do is see where he sleeps.
I need to come
You
in.
can see where he sleeps through that window.
Okay. I need to come into the house.
Okay, the story's changed on y'all twice now.
No. I'm getting a lot of signs that you're not being truthful with me at this point, okay?
No, I'm upset because my husband is standing over there in handcuffs.
Well, he's not under arrest. He's just being detained.
So now you're a psychologist.
No. There is no psychology into that. It's the fact that he's being detained right now.
No,
There
you're
is a
telling me
difference.
that you can tell I'm not telling the truth.
No.
One
The-
of you can come in here. And I'm not, this is against my will. This is against my will. Y'all are invading my home against my will, and a lawyer will be involved in this.
Yes, ma'am. I understand.
Black's Law Dictionary defines duress as any unlawful threat or coercion used to induce another to act in a manner that they otherwise would not. The theory of duress is generally used as a legal defense in instances involving crime, but can also apply as a defense to certain legal violations. For instance, if a person is charged with a crime, then they may raise duress as a defense and claim that they may not be held liable for their actions. This is because the fact that they were under duress caused them to commit the crime or violation. Thus, they may actually be admitting to the act, but contend that they should not be held liable because they had no choice but to do the act. Citizens also have a right to raise a duress defense if force or violence was used to compel an individual to enter a contract or to break one. It could certainly be argued that Miss Dantzler's consent to search was given under duress from the deputies. However, just as with exigent circumstances, it would be left to the presiding court to decide the scope and limitations associated with the duress defense in this particular case. Simply declaring that the given consent is under duress may not satisfy the court's interpretation of the duress defense doctrine.
Don't you come in here.
No,
You
will
do
stay
not
right here.
have,
Coming inside, ma'am.
you do not have my consent. You said you want to see where he sleeps. This is where he sleeps. You said you weren't going to look at anything
I'm
else.
just making sure
This
that
is my office and storage.
I'm just making sure he's not in another room of the house. It happens on occasion, okay? Making sure that he's not in a closet, okay?
No, someone's controlling this young lady's life and she's running from them. Y'all are not taking care of the person who obviously needs help. He's not over there. He's just not a good
Yeah,
housekeeper.
I'm just making sure, that's all, okay? All right? I'm just gonna make sure somebody doesn't get up and stand in the bathroom. Thank you very much, ma'am.
That's it. He's not in here. That's my bedroom.
He's not in the bathroom, is he?
He's not in my bathroom. He is not in this house.
Okay, if I just take a quick look.
No, it is not. He's not in this house.
If he's not in this house,
You
then he's
said
not.
you wanted to see where he
Yes,
lives.
ma'am.
That's what we've done. Where he sleeps. That's what we've done.
Okay, is he in your bathroom?
No, he's not in my bathroom.
Let me look real quick and everything will be fine, okay? It'll take me 10 seconds, okay?
Deputy Hindman searches the bedroom and the bathroom and does not find anyone. The deputies remove the handcuffs and offer to summon emergency medical services to treat the minor wounds that Mr. Dantzler suffered during the scuffle with Deputy Westbrook, but Mr. Dantzler refuses the medical assistance. I have removed this clip from the video due to the graphic nature of the wounds.
Now, folks, Ms. Dantzler, can I speak to the both of you for a second, please?
If you're done, I'd say get the hell out of here.
Listen, again, like I was saying, okay? That's all we needed to do, okay?
Was bully
All
us.
y'all needed to do is that, brother.
Mr. Dantzler, I don't know what you did to my officer, okay? I wasn't
Really?
I wasn't watching when you were walking over there. I was trying
I
to
think
speak
I was
to
the
your
one
wife.
that's handcuffed.
You left me with no choice. But I do want to tell you thank you for letting us come in and make sure that way we know where to divert this back with our city police in possibly another location or anything like that. Again, like I said, it's a medical issue.
It will be the
Somebody's-
last time that you people come into my home. I've tried mentally. I've tried mentally to be in support of you guys. I've tried. I'm an Army brat. 20 years of service. My dad was murdered in Killeen. With what's going on with you guys and the injuries that you just put on my husband for no reason because someone is trying to control Margaret, Marilyn, whatever her name is.
We don't know the female involved now. That's the problem.
No, you don't. But you come out here and you bully these people, tax-paying citizens of this county.
Man, we were not bullying you. I explained to you.
His wrist is almost tore open. It is tore open.
Man, because
I've got it videotaped. He
that's
didn't
fine,
do
that's
nothing.
fine. And it's on video. It's on our video as well, man. Okay? All right. Again, like I said, we explained it to you in the beginning. We asked as nicely as we could. We explained the reason why we're here, exactly the reason was, okay? It's not like we came up here with no reason whatsoever and just told you to get out of here. We didn't do that.
Well, you know what? The Constitution protects us of having military law enforcement come into our homes and abiding in our homes. You know, I've been told by a cop before, if you're so into the Constitution, you must have something to hide. No, the Constitution protects me now.
I will tell you this, if the tables were switched with your son possibly being in some sort of medical exigent
I wouldn't
circumstance,
lie to the police
I understand
to
that.
get
If
them to
he's
control him.
If he is possibly in a medical issue and might be over at somebody else's house and we were meeting with them the same way we were meeting with you this morning.
You know what?
The reasons why.
I
we would
wouldn't
still be
use the
doing
police
exact same thing.
officers unless it was a dire situation to be the nannies.
Because of shit like this.
Sir, I
Y'all
understand.
y'all leave. If y'all got other business, then leave.
The deputies leave the scene without further incident. 3 months after the incident, the Dantzlers teamed up with the Rutherford Institute, a Virginia-based civil rights organization, to challenge the legitimacy of the warrantless search. The following month, a federal court rejected efforts by Texas police to dismiss the Fourth Amendment lawsuit brought by the Rutherford Institute. U.S. District Court Judge David Ezra ruled that the officers' actions as set forth in the lawsuit were based on inaccurate information from an anonymous source and violated the Dantzlers' clearly established constitutional rights. In January of 2018, the sheriff's office agreed to settle the case before going to trial for an undisclosed amount. Overall, Deputy Hindman and Deputy Westbrook get a C- because although they seem to be acting in good faith and genuinely concerned for the well-being of an individual who may be in the midst of a medical emergency, the deputies stretched the boundaries of their authority without consulting any higher powers and ultimately violated the Dantzlers' rights in the eyes of a federal court. The deputies carried out their duties based on unreliable information, but it is difficult to attribute that fault to the deputies alone, given that many police departments suffer from a lack of sufficient communication. It is very likely that these deputies were just doing what they were told to do and were unaware of the reliability of the information which they were operating under. It is beyond the control of these deputies to verify and assign legitimacy to the information that the department receives and acts upon. The feeble information verification process and deficient communication channels and procedures of police departments is a nationwide issue that has no simple solution, and it is unreasonable to place the burden of fixing that system on one department, much less two deputies. Mr. and Mrs. Dantzler get an A- for challenging the validity of the deputy's search and following up this encounter with legal action. Although Mr. Dantzler did unnecessarily resist detainment and prompted Deputy Westbrook to engage in a scuffle, the Dantzlers were still able to walk away from this encounter with compensation. This interaction is an excellent example of the services that civil rights organizations can offer to individuals who are wronged by members of law enforcement. The Rutherford Institute deserves high praise for taking on this case and securing indemnity for the Dantzlers, and I commend them for their representation in the courtroom. Let us know if there's an interaction or legal topic you would like us to cover in the comments below. Thank you for watching, and don't forget to like and subscribe for more police interaction content, and check out our Patreon for even more encounters.